Thanks for joining us this afternoon, America. I'm John Stubbins, your host here on Indivisible with John Stubbins, and we're glad to have you. We're streaming live today on pilled.net, freedomfirstnetwork.com, Twitter, YouTube, nada. So welcome. A lot in the news. We're not going to be able to get to most of what's happening with the election today because we're going to be dealing with another issue. So, America, are you fed up with having your Twitter account being suspended or your Facebook post being labeled as false information by so-called fact checkers who are actually scumbags, shills for the radical left? They're leftists, they're Marxists, Democrats, obviously, and they're there to make our lives hell. I thought so. I thought that you had it. I know that I have. So isn't it, heck, President Trump's tweets, his posts on Facebook, they're not even safe. And, nothing's safe really to share unless these so-called fact checkers deem it to be worthy. So the question is, who exactly is it that put these tech companies and these fact checkers in charge of what we do and post and what we want to say, our free speech? Who are they to get to decide what's factual, what's false information, what's real information? And they've been running this evil masquerade for way too long. Did it affect this election? You bet it did. How many votes? Millions. Millions were swayed. Information wasn't given to people. Let's take President Trump's warp speed on the vaccine, for instance. Millions of people were, polled, said they'd never heard of warp speed. How is that possible? They've never heard of warp speed. So they didn't know that the president had put together a program to bring America the vaccinations for this Wuhan virus. Millions didn't know, just magically. No, it was big tech, it was Facebook, it was YouTube, it was Google, it was Twitter, it was all these companies that decided that they weren't going to allow the American people to get that information. So they deprived you of valuable information. And I'll go a step further with that. These same people that were polled, at least 5% minimum, said that they would have voted for President Trump in this last election if they had known about warp speed. Just to give you an idea. So, censorship, that's what we're talking about today. That's how they did this. Censorship. Taking away your right to free speech, which I thought, and I'm sure you all thought, that was a guaranteed right in this country, given to us by our Constitution. Okay? So that is on the line here today. And if you're not prepared to fight for it, I don't want anything to do with you. If you are prepared to fight for it, you're going to want to tune into this show. And speaking of censorship, I want to welcome onto the show my guest today, Jason Fyk. Jason, how you doing, brother?
I'm doing good, John. How are you, sir?
Well, this is a very disturbing subject, but it's one that I know people want the breaking news on this that we're going to give them today. And Jason, by the way, folks, knows all about censorship. He's going to tell you today. I'm going to shut my mouth once we get going here and let him tell you. But he knows all about this. And in fact, he just has a case that's been filed with the U.S. Supreme Court, SCOTUS docket number 20-632. And I'm going to go, Jason, as you start to elaborate on this, I want you to just start to tell our audience from the beginning about this. And I'm going to be showing some pictures about these articles as we go forward.
All right. So, yeah, I mean, if we go back to the beginning of the story, you call it censorship, First Amendment issues, right to free speech. The complication is that, I think a lot of people know at this point that Section 230 is one of those things that it's a law that was enacted in order to do one specific thing. A lot of people, you know what, I'm going to actually explain the whole thing for you. Okay. So Section 230 was originally enacted. It is a law, and it was designed to do one very specific thing, which was to protect children from harmful content. Makes sense, right? We want to be able to allow these sites to be able to take down certain content that could be harmful to our kids. It was all well intentioned, right? And the thing is that when that happens, when they start to take down content, what the result of that is that they would then be liable for all of the content that was on their site that they didn't take down. Make sense? Because if they would then be acting as a publisher, and that conversation comes up all the time. They're a publisher, they're a platform. Well, today I'm going to explain exactly what that means and what it means in terms of the legal aspect of it. Okay. So I have spent countless hours going through this, and I figured out something that nobody's really figured out. And to understand 230, we have to look at the principles of it. So it was designed in a way that it was supposed to be to allow these sites the ability to protect our children. So they were going to be acting as a good Samaritan, right? The good guy,
Sure.
right? Now, you would think that they might put that into the law somewhere. Well, they did. It's actually called Protections for Good Samaritan Blocking and Screening of Offensive Materials. And Good Samaritan is literally in quotes in the law. Now, the reason we say it's in quotes, now, we don't have this specifically, but we believe that the reason they put it in quotes was to specifically emphasize that you got to be a good Samaritan. Now, to date, the courts have not recognized, except up until recently, there was a case called Enigma versus Malwarebytes where the motivation counted. Motivation matters, right? Because if you, let's say you take a lollipop from a child, right? It sounds like it's a bad thing, but what if that lollipop was poisoned? If the good intention was there to do something that the kid wouldn't like, you're still a good Samaritan, right? But if you're just doing it to take the lollipop away, then you're not a good guy. So a lot of the courts have not recognized that at the core of any lawsuit, you should initially ask yourself, were they acting as a good Samaritan? And Good Samaritan's fairly simple to give you an idea of Good Samaritan, right? A Good Samaritan, so say, for example, you're driving down the road, right? And a car crashes in front of you, catches on fire. If you run over and you break their window out and you drag them out of the burning car, right? And you put them on the side of the road and you save their life, you cannot be sued for breaking their window. Now, if you broke their window for no reason, you would. But because you were rendering Good Samaritan care, you're not liable. It basically incentivizes the companies to act as a good Samaritan. That's where it starts. That's where 230 starts. Now, the first thing is motivation, right? Then you have to ask yourself, well, if they were a good Samaritan, if they say, okay, well, we don't know, they might have been a good Samaritan, they might not have been. We then go to the next piece of the law. The next part of the law is, so C is a good Samaritan. And then C1, and it's like an outline for those that don't understand it. It's C1, and C1 says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of the content of another. What that means is that if you, John, were to put up that Jason Fyk is a jerk on Facebook or Twitter or Google, Facebook and Twitter and Google would not be liable for what you said, right? Because you're the publisher. You put the content up, right? So only you're responsible for that content. Right. Now, the reason for that was because if they're taking content down, they would be responsible for anything that was left up. So this protects them in the circumstance that they didn't do anything, nothing. But remember what I just said. If they did nothing, okay? I'll come back to this. Right. We're going to go back to C1. This is where things start getting really, really hairy. So then the next one, C2. Okay. There's C2A and then there's C2B. C2A is really the one we deal with because C2B is, I'll explain in a second. So C2A, and I'm just going to paraphrase because it's fairly long just to quote it, but it allows you to restrict materials, right? Which is anything. Could be any content, anything you want, whatever it is, they can restrict materials, but they have to do it in good faith and they have to do it voluntarily. Okay. Now, what that means is remember, that applies back to the motivation. Were they acting as a good Samaritan, doing it in good faith as a voluntary, service to restrict materials? Now, why were they restricting materials? Because they wanted to protect children. So when it says offensive in 230C, they meant offensive. They meant, it was literally, they came out with this big book. It's called the Big Book of Smut. They stuck it in front of Congress and they said, this is what we need to take off the internet. And it probably was a lot like Pornhub, but whatever. Okay. But we all know, it's kind of like, how do you know that something's offensive or objectionable? You just sort of know when you see it, right? But the problem is that in that law, it says lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. You see this color right here? That could be objectionable. It could be that dumb. It can be anything can be objectionable. So Facebook, Twitter, and Google started realizing that if they just build their community standards and the terms of service, that anything is objectionable, they can pick anything that they want to remove, can't they? And they go, oh, well, we did in good faith. We're saving the world here. Hey, I don't like your political candidate. I don't like your ideals. I don't want you making money. That's a problem because that's not really good faith, is it? Now,
no.
What happened in my circumstance, let me explain, and how I've got them jammed in a corner here, is they restricted materials, so C2A, right? Now, all C2B is that it allows, like, if the site gives you the ability to restrict materials for yourself. Same thing, but it pretty much protects everything anyhow. So let's take my scenario, right? They shut down 6 of my pages, 14 million fans overnight, right? No reason at all. So we have to assume that something I did in some way was objectionable or offensive, right? 6 of my pages. Now, it was coincidentally that it was 6 of my pages, not all of my pages, and they were just the ones that weren't verified. But let's give them the benefit of the doubt and say, yeah, it was offensive content, right? No matter what it was. Okay. Now, fast forward 4 months, and I go to a competitor of mine who had spent a lot of money with Facebook, who I actually helped launch. And I said, hey, look, guys, I know you spend a lot of money with Facebook. I know you have reps that you work with Facebook. Can you see if you can get my pages back, like get them republished? And they asked Facebook, and Facebook came back to them and said, no, sorry, can't do it for Jason Fyk. But if you guys own them, we can restore them for you. Oh, really? So, left with no other choice because they're worth nothing to me, right? Unpublished, a page is useless. Nobody sees it. So I go and I sell it to the other company. And sure enough, 3 days after they've got control of it and the contracts are done, and even Facebook was involved in the transaction, all of a sudden, the pages came back. Well, guess what? Whatever my content was when it was shut down, what was the difference when it was turned back on? Same content, right?
Great question.
The only thing that had changed was who owned it. So now what I've proven beyond any doubt whatsoever, it was never the content. Ever. Can't be. Because whether I had puppy dogs or elephant penises,
of course not,
doesn't matter, right? So now I've got them jammed. So what do we do? So we go and we sue. And I sued him in 2018. And we basically dismantled C2A. Good luck with that. 230 C2A, you did not do that in good faith. There's no way you can do it. And they came back with, I was treating them as a publisher or speaker of my own content. Wait, what? Mm-hmm. You restricted my materials in bad faith. That's C2, but you flipped to a C1 argument. And I'm going, What just happened? Well, get this. Northern District of California decides that they're going to dismiss it. They agreed. They said, nope, you're treating them as a publisher or speaker of my own content. I'm like, no, I'm not. They did what they did, and I did what I did, and they restricted. And I'm going, what is going on here? Ninth Circuit did the same thing. Now, here's the interesting part.
Mhm.
Very, very weak answers when they gave their rulings. I mean, they were talking like 5-page rulings. They were really short, and like 2 of them are boilerplate stuff. But here's what's interesting, and I'm going to pull this apart, and it's literally an epiphany when you realize it and you understand where the mistake went wrong. You go, oh, I'm going to win this. Here's why. Because I hear all these arguments that it's already it's settled law, it's a First Amendment issue, they can censor if they want. All of those laws are, all of those arguments are irrelevant. It's a textual issue. You know how they say to the letter of the law, right?
Yeah.
Every word is important. Every word. Okay. Keep that in mind. So now the court said that I was treating Facebook as a publisher or speaker of the content of my own stuff, which I am. But the thing is that they restricted my materials, and the court literally said, in quotes, that restricting materials is something a publisher does. Okay. So if I can't treat them as a publisher under C1, and C2 is actually acting as a publisher, they're not responsible under C1 for C2. And we then brought up the argument that, well, that's a conflict, because and I'll give you another good example here. John, if I told you you can't make a left up here with your, when you're driving down the road, you can't make a left up here. But, oh, by the way, the first law, C1, says that you're not allowed to drive. See the problem? If you cannot be treated as a publisher, what is the point of having a publisher function? Because you don't need C2 anymore. If the one would just envelop the other, the C2 would be useless, right? You can't have that happen. The Supreme Court's already said that. It's a conflict of law. So we have to harmonize it. Do you know how they harmonized it? This is great. This is and I'm trying to get you, like, everybody to understand this. It's really complex. So in order to basically fix this screw up, the courts then quoted Batzel, which was wrong. And Batzel said that C2 provides a separate grant of immunity, quote, perhaps because they developed information in part, end quote. Wait, what? If they developed information in part under C2, what is that? What does that mean, right? Well, let me get into this a little deeper. Remember what C2A does. It restricts materials. There is nothing in C2 that allows you to provide materials, right? It doesn't say it. So it's only the negative, only taking content down. That's all they can do. They can't put it up. They can't advance. They can't mess with it. So what exactly is perhaps development in part? Well, Ted Cruz just recently brought this up in front of Congress. He actually quoted 230 F3. F3 is not an argument that really has a ton to do with it, except it does, because F3 is a definition. It's the definition of an information content provider, not restrictor, provider.
Gotcha.
Okay.
Gotcha.
So a provider is not in any way, shape, or form protected, because in the first one, C1 says the content provided by another. If it's provided by them, they're not covered. And restriction of materials is C2. It's not provider again. So if they're providing information in any way, shape, or form, they're on the hook. So the question is, does C2 allow them to perhaps develop information in part? That's the exact language they gave me. 230 F3 says, any person or entity who is responsible in whole or in part for the creation or development of information provided online. In other words, if you're perhaps developing information in part, which is a very low burden. And remember, creation is to bring something into existence. Development is simply manipulating. If you advance the distribution of, if you provide more context for fact checking, if you help sponsor posts because you're taking money to take responsibility for the development of that information, guess what? You're a content provider. Their entire business model is a content provider. So guess what? If F3 is a content provider, then the Ninth Circuit's decision that it perhaps developed information in part is wrong about C2. Therefore, C2 is a publisher function, which would then be enveloped by C1. See how this is getting, we're going around circles here? But C1 would then swallow C2. We can't have that happen. So what happened? Where did it go wrong? Are you ready for this? Where did this all start? I had an epiphany. And when you understand this, it's like, no way. It was this simple. So I was watching Judge Napolitano one day talking about the right to free speech. And he asked his law class, do you know what the most important word in the right to free speech is? Do you know what it is, John? Do you know?
Right.
Nope.
I would say.
What would you say?
The.
That is correct.
Would it the?
Yep. So
Okay.
what happened is that he went on to talk about James Madison argued in the Federalist Papers, right? So this is our founding fathers talking about constitutional law and natural rights, the right to free speech. It's irony that this is actually based upon the right to free speech in the First Amendment, right? The right to free speech, he argued that the word the was incredibly important because it denoted that the right pre-existed any potential abridgment. It was the right. You just had the right? It was just there. Now think about that. Pre-existed, okay? Let's go back to what they said about 230 C1. The Ninth Circuit Court said that I was treating Facebook as a publisher or speaker of my own content. Well, what does the law say? The law says that I cannot treat them as the publisher or speaker of the content of another. The denoting that the publishing pre-existed, meaning I just cleared up the problem that they can be held accountable as a publisher, but not the publisher. Guess who else?
So it's a publisher versus the publisher. Got it.
And what has happened is that the courts have just said you can't be a publisher. You can be a publisher under one circumstance, that you restricted materials in good faith. That's it. That's what C2 does. It allows them to be a publisher in one function. That's it. None of this garbage about picking which is authentic. None of this garbage about sponsored ads. None of this garbage about fact checking. None of that's covered. I just ripped them in half. But here's the best part. Here I'm a guy. Maybe nobody knows who the hell I am over here, just working on a Facebook suit, whatever else like that. And I have people telling me I'm wrong all the time. Why did I waste my money? And so, well, let me tell you, there was somebody else that agreed with me. Do you know who that was, John? Justice Clarence Thomas.
Yes.
October 13th, he rendered an opinion in the Enigma versus Malwarebytes case on a denial of cert, which is unprecedented. It never happens. And he went on to actually define it as the primary publisher and the secondary publisher. The publisher is the primary publisher, and then the secondary publisher is a publisher. There is a difference. And he also said that in the 24 years that the Supreme Court has been around, or excuse me, the 24 years that the CDA has been around, it's never been interpreted by the Supreme Court. And then went on to say that the Enigma case wasn't the appropriate case to handle this, but if the appropriate case were to come along, that it would be in the behest of the Supreme Court to handle it because, of course, it's a global problem right now, that 230 is way too broad, but it will go back to a modest understanding where they will either not have anything to do with the content, or if they do, they can restrict it in good faith and only good faith. Their motivation still has to be that of a good Samaritan, and it will fundamentally change the entire internet. But you know what? He said if the appropriate case were to come along, I filed 2.5 weeks later in the Supreme Court of the United States of America. We can change this. We can fix all of it. The Supreme Court is the place to fix this because Congress can't get it done. I can't even believe it. Nobody in Congress has even reached out to me, and I'm the only CDA case right now that's pulling this apart, and now I'm at the Supreme Court level. It's the SCOTUS that handles this. They fix misinterpretations in the law. This is not a First Amendment argument. This is not a censorship argument. This is not any of these dumb arguments that all these experts have put out there. This is a textual argument. It was misunderstood from the beginning, which caused a sequence of mistakes that went down, and one word changes the whole damn thing. Let me
ask you something real quick, Jason. So by Clarence Thomas agreeing with you, what does that do now for this case at the Supreme Court level?
So he didn't actually agree in the sense that, well, maybe he did read my briefs. I don't know. I have no idea. But I had shown the link to my Medium article. I wrote this Medium article to explain the CDA the way it is supposed to function in 230, and I explained it as cleanly as I could in plain English. I think it's pretty good. But if you then follow the link out to what Justice Thomas says, it's a mirror. It's substantively what he said, and he completely could have done it on his own, but he's right because I agree with him. Whether he agrees with me or I agree with, doesn't matter. We are in agreement that this is how it works. Yes, this is how it works. It should have worked like that. It's a modest protection. And at the end of the day, if they simply sort out that one word, all the rest sort of has to fall into place. We fix the internet. And the censorship thing that everybody's talking about, yes. Can they still censor? Yes. However, Good Samaritan, good faith, and voluntarily will apply. Right now, it's not applying because they are literally kicking back to that C1 argument, which is exactly what they did to me. Oh, we restricted your materials in bad faith. Oh, okay. Well, 230 C1, you can't treat us as a publisher. Yes, I can treat you as a publisher. I'm not treating you as me. I did what I did. You did what you did. See the difference?
Mm-hmm. Yep.
It's a big change. And I'm surprised that more people aren't catching on to this, because it's when you realize that one word has changed, it fundamentally changes the internet. I mean, it will legitimately change everything. Cat's out of the bag now.
And Jason, I just want to thank you for bringing this to the forefront. This is such huge breaking news. Let me ask you a question. You've got the SCOTUS docket number 20-632. When is the case going to be heard?
So we filed November 2nd, day before the election, and Facebook has 30 days, I think, but they may ask for an extension, but either 30 days or an extension. And then we have 15 days to reply to that. And then the Supreme Court will make a decision. Okay. And I suspect they're pretty busy right now with all this stuff, so I wouldn't mind if they delayed it. But obviously, this affects a lot of people, so it's important. But But
it is coming forthwith.
Exactly. We're talking about we should have a decision rendered by the Supreme Court, give or take, in 6 months. So 230 is going to change.
Yeah.
At some point here, and it won't require, because the other thing that I also want to address is that we can't repeal 230. 230 actually has a good intention, because if you repeal 230, it becomes the absolute wild, wild west. There's no all the liability. It would be a disaster. Honestly, the ramifications are huge. But then you're talking about Congress trying to fix the law. How do you fix it? Because when you start getting into refining laws, honestly, it's a very elegant law. The problem is that only California courts have handled it because all of like there's just no technology past the West Coast. So like no other circuit courts have really handled this, but it's really that's all the difference being is that the primary and secondary publisher has to be distinguished. And this, if they're a secondary publisher, the only thing they can do is restrict materials, and it has to be done as a good Samaritan in good faith. That's it. So if the Supreme Court fixes that 6 months from now, I'm seeing Facebook changing its terms of service, trying to say that you can't join a class action and whatever. I don't see how you can just change your rules and say, hey, you can't join a class because we did something wrong. They did a lot wrong. I'm amazed they have not tried to just get me out of this lawsuit at this point, because right there, I mean, you're not a lawyer, are you, John?
No, I'm not.
Are you a lawyer?
But Mom really wanted me to go to law school.
Well, no, but my point being is that you don't have to be a lawyer. What I just explained to you makes sense, does it not? That if the one word is different,
absolutely,
it's not right.
Look, just because I didn't go to law school doesn't mean I don't understand the terminology. And secondly, some of my best friends are attorneys. So
yeah, well, that's what I'm saying is
I get it.
To be a lawyer to understand
it's just interesting,
right? Everybody's been on the wrong path for the long time, and I'm just saying, no, it's the right path.
Yeah, and what's interesting to me about all this is the American public, when this show is shot out everywhere, and they get this, that it's a simple changing in the wording that's going to make all the difference for them and every one of us on social media. People are going to start to celebrate because they know that your case is coming and that change is imminent. And that's great news.
Change is definitely imminent, because even if it's not me, the reality is the path is out there. Other lawyers have looked at this. I've had lawyers that you're even skeptical look at this and go, whoa, you've got this. I'm like, I do. Yeah. Like, we've got this figured out. It's really not.
Yeah. And look, fine. Whether you believe Clarence Thomas has reviewed every piece of your document or not is irrelevant, because if it comes before the Supreme Court and Facebook has no challenges to your case, then Clarence Thomas is going to be involved anyway. And he's a man of common sense. So therefore, he's
very, very smart man.
I feel very good.
Yeah.
I feel very good about Section 230 being changed.
Correct. The irony is it's actually not changing.
And that
is interpreted correctly. Yeah.
Let's say that.
So that's where we're at, John. It's just a matter of time.
It will finally be interpreted correctly, but it'll be pointed out. It'll be pointed out legally that change and distinction in the wording that matters.
Right. That's right. That's why, more than anything, lawyers all across the country need to pay attention to this. And I'm willing to speak to anybody. I'm not really constrained in my lawsuit, because everything's on the table. We know what happened. It's all out there. I've figured this stuff out. I can consult on other cases and so forth. But I know a lot of people want to come after them. Here's your way. It's just a matter of we've had to take it all the way to the top. I mean, this is a long fight. Matter of fact, if anybody wants to help with this fight, I have a site called All Fundit, ALLFUNDIT. If you look it up, FIC 230. I've got a long fight ahead of me, and it is expensive. I've basically thrown everything into this I can. I don't do anything without the intentions of winning, and I knew I was right.
Let me just say this to you, Jason. First of all, I'm dealing with a huge whistleblower story that's going to really everything that's happening right now. But once we get through this election nonsense and the legalities involving the election, plus my whistleblower, the insurance policy, America, and there's going to be a lot more that I'm going to be talking about the insurance policy that's going to rock your world. But once we get through this, I'm glad that this takes 6 months, because that's going to buy a little time. And then what I'm going to do is I'm taking this and I'll give this whole interview to my friend Sidney Powell and Lynn Wood. And I'm going to make sure they have it on their desk. Let them get through this current fight on. And I promise you, my friend, we're going to have it for them.
We're all fighting for the right thing now, which is the best part.
Yes. And I want to salute you, Jason, for coming on. Is there anything you want to add before we let you go to the audience?
Just know that the biggest thing that I'm watching in America right now is just people are lazy. That you need to just not stop. If I had given up because I lost in the Northern District. I lost in the Ninth Circuit. I lost en banc.
That's right.
I don't think I'm going to lose in the Supreme Court, because right now I've got one of the 9 justices that sees it the way I see it. You just can't give up. Don't give up on Trump. I've even seen conservatives, which I'm a little disappointed in. Why does he concede? You can't concede. What he's up against, you just can't. I don't want to go too into the politics thing, but at the end of the day,
Jason,
don't stop fighting.
Jason, did you see? I don't know if you caught it. I was trying to watch it before we came on for today's show. Did you see the Pennsylvania hearings in the Senate there in Gettysburg?
I haven't had a chance. I've been a little busy today.
I don't know if you caught that.
Was 600,000.
That's okay. I've been busy. I'm with you. I've been slammed too. But just America, I just want to let you know, like I said, I'm dealing with this whistleblower situation that's going to be probably the biggest story in American history, aside from the election and aside from the Section 230 story. But Rudy Giuliani, Jenna Ellis were at the Senate hearing in Pennsylvania today in Gettysburg, and everybody understands now what's happening with this election. So stay tuned, because this is not over. It is not over.
Not even slightly.
Jason's absolutely right. Those of you that have given up, shame on you. Shame on you. Jason, thanks for joining us today, brother.
Thank you,
God
John.
bless you.
You too. Take care.
Everybody, I just want to stress again, this election, what's happening with Jason today with our show, with Section 230, with the election, General Flynn, all of it. The Bidens over in Ukraine and China, the dirty money from the Clintons and the Bidens and the Obamas, how they achieved all that money, it's all coming, including the money that was sent to Iran, the money that Obama had no right to send. It was all treason. It's all connected. We're going to be bringing it to you very, very with the insurance policy. So I want to make sure you stay tuned into Indivisible, because we're going to be breaking news very soon on this. Okay. I'm working with Sidney Powell. I'm working with the legal team. We're actually waiting on a call from Senator Ron Johnson from the Homeland Security Committee, and also Rudy Giuliani on these matters. So just stay tuned, America, and have faith, pray, support your president, and remember to put God first. Thanks for joining us today on Indivisible, America. God bless you all, and happy Thanksgiving.